Lien versus title theory. How does it impact homebuyers and homeowners? Have you ever noticed that in some states a court proceeding is required to foreclose on a property, but in others it's not? Or that the documents related to buying a home are called different things, like a deed of trust versus a mortgage? The reason for this depends on whether you live in a lien theory or title theory state. In this video, we'll discuss what each of these terms mean, how it affects the process of transferring title to property, and how it impacts foreclosures. But before we dive in, a little background. English mortgage law follows a title theory framework. So early settlers in the United States required that title ownership of a property be held by the lender until the debt was satisfied. In 1791, South Carolina attorneys successfully argued that a foreclosure proceeding was required in order for a lender to acquire title. A mortgage, they insisted, despite its wording, simply created a lien against the title. After that, the Act of 1791, South Carolina was passed, and it became the first state in the Union to subscribe to lien theory. Since then, 20 states have adopted the theory. Now let's talk a little more about what title theory means. Basically, this means that when you go to buy a home, your lender will retain title rights to the property and allow you, the borrower, to occupy the residence as if you own it. During a real estate transaction, the seller actually transfers the property to the lender. The lender holds the actual legal title on the property, while the borrower holds the equitable title. The lender holds the title to the property in the name of the borrower through a document called a deed of trust. When a borrower finally pays off their loan in full, a deed of reconveyance is issued and the debt is officially extinguished in the public record. There is no court proceeding to determine if the borrower has any merit to contest the foreclosure. These non-judicial foreclosures are conducted in accordance with procedures established by state statutes, which usually include mailing a default letter to the homeowner and filing a notice of default. If the homeowner doesn't address the default within a state-specified time period, a notice of trustee sale will be mailed to the homeowner, posted in public places, recorded in the public record, and published in regional legal publications. After that, the property is put up for auction or a trustee sale and sold to the highest bidder. So what about lien theory? In lien theory states, the borrower holds the title to the property. Instead of a deed of trust, a mortgage is recorded in the public record and acts as a lien against the property until the debt is paid off. With a mortgage, a homeowner has both legal and equitable title. When the mortgage is paid in full, a release or mortgage satisfaction is filed in the public record to remove the lien. Should a borrower default on a loan in a lien theory state, a judicial foreclosure is required for a lender to take possession of the property. During the 2008 housing crisis, many borrowers in default used a produce the note defense in foreclosure proceedings that required lenders to demonstrate they had the legal right and authority to enforce the note. The promissory note acts as an official IOU, so if the loan is sold off to another entity, both it and the mortgage must be properly transferred. While the defense is unlikely to be used successfully today, and some states like Florida have addressed the problem with a law requiring the note at the time of foreclosure, the process gives homeowners a chance to defend their rights to the property, and it requires lenders to meticulously track and file the proper paperwork before foreclosure proceedings. A judicial foreclosure usually begins with the filing of a lis pendens, which acts as a complaint against the borrower. The borrower is given a notice of complaint by either mail, direct service, or is published in newspapers, and he or she will be given opportunity to be heard in court. If the court finds the debt is valid and in default, it will issue a judgment for the total amount owed, including court fees. Like in title theory states, when a lender is found to have a valid complaint against a borrower, the house is auctioned off. Unlike title theory states, there is an additional step in which the highest bidder is subject to the court's approval of the sale. Once that's granted, the highest bidder becomes the new owner of the property. In addition to lien and title theory, some states have taken an intermediary approach. In these cases, the borrower retains the title, but the lender can take it back without judicial proceedings if the borrower defaults. The deed of trust lists the borrower, lender, and a third party called a trustee that holds the title until the loan is fully paid. Typically, the trustee is an escrow or title company. If the borrower defaults on the loan, the lender provides the trustee with proof of delinquency and requests that foreclosure begin. The trustee takes control of the property and sells it on behalf of the lender. If you want more tips on home buying or you want to get some great real estate news, be sure to subscribe to our YouTube channel. If you want to learn more about which states use either title, lien, or intermediary theory, be sure to check out the link to the blog in the description below.